Next up, the third hearing on Senate Bill 154 regarding long-term care residence room monitoring. Eli Fax from Leading Age Ohio.
Good morning, Chair Huffman, Vice Chair Johnson, Ranking Member Liston, and members of the Senate Health Committee. My name is Eli Faze, and I serve as Public Policy Director for Leading Age Ohio, which represents mission-driven nonprofit providers of aging services across the state. Our members provide a continuum of care to older Ohioans, including nursing facilities, assisted living communities, and other residential care settings. Thank you for the opportunity to testify as interested party on Substitute Senate Bill 154. So you have my written comments, and I know it says Susan Wallace on them, but she was unable to make it today. So I'm going to touch on just a few of our points here, which are basically the privacy and dignity of residents, HIPAA compliance, and bandwidth issues. So Leading Age Ohio understands and appreciates the intent behind Esther's Law, which was enacted in 2022 to provide residents and families additional transparency and reassurance regarding the care being delivered in long-term care settings. We worked with the sponsors of that original bill and supported our members throughout implementation with sample policies, forms, and other tools to ensure compliance. One of our concerns with the current draft center around are related to the secure transmission and storage of protected health information. First, we've learned that the information contained in the feed, whether it's patient identifying information, data related to the resident's health status or care, or private images of the resident, is not considered personal health information if the resident is the one filming the information for their use alone. However, in shared rooms, which remain common in many long-term care environments, it creates additional challenges. Cameras or audio recording devices may capture conversations or care activities involving another resident whose protected health information could be recorded without their knowledge or consent. For this reason, we recommend the bill be amended to require not only the written consent of any roommate before any electronic monitoring device may be used, but also an authorization to disclose protected health information to those individuals who will be accessing the device's recording to protect providers from HIPAA-related litigation. As the technology evolves, particularly with devices capable of audio recording or two-way communication, it's important that any monitoring authorized under statute operate in a manner that protects resident privacy and complies with applicable federal and state privacy laws governing protected health information. Second, the bill's provision related to internet access may create additional operational challenges for providers. As currently drafted, the legislation appears to require facilities to provide internet access for monitoring devices if it is available within the facility, while limiting the ability of the providers to recover certain costs associated with expanding or upgrading their internet infrastructure. In practice, many of the monitoring devices currently used are consumer-grade internet-connected cameras that rely on continuous video streaming. When multiple devices operate within a single building, they can significantly increase bandwidth demands and affect reliability of internet services used by residents, families, and staff throughout the facility. In some cases, providers may need to upgrade network infrastructure to ensure service remains reliable and secure. Allowing providers to recover the costs associated with connectivity and installation with limits for residents under the Medicaid program would help ensure these devices neither degrade service quality for other residents nor create new unfunded obligations for long-term care providers. So, Leading Age Ohio supports policies that enhance resident safety, dignity, and transparency. We believe the goals of Senate Bill 154 are achievable, and that with several or a few targeted tweaks and clarifications, the legislation can better address privacy protections and infrastructure realities within long-term care settings. So we appreciate the committee's consideration and look forward to continue working on this expansion of Esther's Law. Thank you very much, and I'm happy to answer any questions.
Any questions? Yes.
Thanks, Mr. Chair. Thank you, and I do have your information. Esther's Law does require, if indeed there is a roommate, that there be permission granted. So that's already in Esther's Law and covered.
Through the chair to the senator, we just want some more clarity in the statute as written. To ensure that we have that. And I think that there might be, some amendments forthcoming that we would like to take a look at and possibly support.
Okay. Can I ask a question about it?
Sure, of
I mean, maybe I can.
Since it's,
So is there, how do you, so should there be a consent with the roommate saying your HIPAA may be violated because there's a camera in the room? Or are there HIPAA compliant cameras out there? Because I don't know how we get around this without the consent of the roommate, because the camera may be focused on one patient, and in the other bed, she may not even be in a room. In the other bed, the doctor comes in and starts to talk about their health care, and they're the only two in the room, but the camera's on. How do we get that to be HIPAA compliant?
Mr. Chair, and that's one of the concerns that we have, right? So I think that with informed consent and making sure that we have the consent of those shared rooms with roommates, and I'm not sure what that would look like. That's something that we would have to work on and do a legal analysis as far as HIPAA compliance. But those are sort of the questions, even as Esther's law, in practice today in nursing facilities, and kind of opening up to other care settings, that, since we're revisiting the statute with Senate Bill 154, we think it's time to kind of look at those to make sure that everything's squared away.
So are you asking to go back and revise what Senator Ingram passed as Esther's laws and say, hey, look, you guys screwed this up. You should have put HIPAA compliance in it because there's a problem with that?
Mr. Chair, I think it's like with a lot of things that get passed, once it's operationalized for a few years, new concerns come up, new questions come up. You see where providers might have questions or needs that need to be addressed that maybe weren't considered fully when the statute was originally passed. So again, we see this as an opportunity to kind of close some of those loopholes.
Any other questions? Seeing none, thank you very much. I'll make note to the members of the committee. There's a couple written testimonies here. That is all on the agenda. Is there anything else before the committee? Seeing